Good morning, Ms. Sibison.
Good morning, Your Honor. May it please the Court, I'm Wendy Sibison. I represent Kimberly Dahms Cook, that's her married name, in an appeal from a defense verdict in her complaint alleging workplace...
I have an evidentiary question for you.
Yes, ma'am.
Because I think this point is important, and that is the failure to admit the propensity, the failure to admit the telephone call, the contents of the telephone call. The telephone call from Japan.
Yes, Your Honor.
I've gone through the transcript on at least that issue, and it seems to me you raised the point that it might have been an excited utterance, that it might have been admissible for that reason. It seems to me, and this is what I'm really questioning you about, that I'm not sure you raised the state of mind exception, but it seems that your adversary raised it, and so it was before the court. So I'm just wondering what your position is on whether that issue was raised before the court, the state of that the conversation should have come in for the plaintiff's state of mind.
Well, it's a good question, whether or not our counsel, our defense, our plaintiff's counsel actually enunciated those words, prior consistent statement. He didn't. On the other hand,
not prior consistent statement.
I believe that actually was it.
Okay. Well, what about for the woman's state of mind?
Well,
because her state of mind was at issue, was very important in this case. So,
whoever said it, Your Honor, I think the record shows that it was before the judge. The issue was before the judge, and actually, the court will have to decide whether it was perfectly raised or not. But nonetheless, the judge had all the admissible theories before him, and he excluded it. What's interesting about this issue, and we might as well start at that, is that to the extent that this court will have the opportunity in this case to analogize the same sorts of protections that are available to rape victims or rape complainants in criminal cases should be made available to civil complainants in cases where alleging sexual
but you
misconduct.
have so many problems in that area. I don't see why we have to analogize. I don't see why we can't decide it on whether it's relevant in this case.
Well,
it either is or it isn't.
Well, you can, Your Honor, but the reason I want to say this is that in this court's mass guide to evidence, in Rule 412, this court actually did say some things that aren't yet the law of Massachusetts, which is to bring in within the purview of that rule. But nonetheless, my point is that in the rape context, this court has over and over said that because society tends to disbelieve victims of sexual misconduct, and particularly those who don't complain right away, this was a perfect example of fresh complaint evidence that the judge didn't exclude. And with response to whether it was properly preserved or not, this is the last issue in my brief, Your Honor, but nonetheless I think it's important because this was the worst example of sexual aggression.
It wasn't the last issue. The last issue was the movie issue, the data release of the movie.
I beg your pardon. Thank you, ma'am.
So are you saying you don't think it was preserved? Or
I think it was adequately preserved. It was offered into evidence. Counsel enunciated several bases for it. Defense counsel enunciated several bases for it, which he hadn't mentioned and said that shouldn't apply. That ought to be enough to preserve the issue. Okay. May I proceed? This case presents an important opportunity for this court to address a persistent barrier to justice for victims of sexual misconduct, and that is society's tendency to disbelieve victims of sexual misconduct, and particularly those who don't complain right away. Overall question in this case is how, in the civil context, can this court help level the playing field? What happened here is an unfortunate blueprint for why so many victims of sexual harassment still do not come forward. What happened here was aided by a staggering variety, or at least a surprising variety, of unfair rulings. The defense was allowed to persuade the jury that Kim Dahms, who had always been treated as a brilliant young engineer and rising managerial star, suddenly, after she complained that the CFO had been harassing her, turned into someone, in the jury's eyes apparently, who welcomed and encouraged these sexual comments and conduct, falsely accused him of sexual harassment, filed a false MCAD complaint, threatened to quit and violate her non-compete agreement and therefore deserved to have all sorts of workplace restrictions placed on her, and then did a terrible job and deserved to be fired, and then lied about all of this to the jury.
But these are all jury questions. These are exactly the things that the jury
Yes, Your Honor.
decided.
And what my point is that these jury questions were unfairly decided because of all these unfair rulings that the judge made. And to be specific, on the sexual harassment business, a charge to the jury telling them that they must render a defense verdict if my client engaged in, quote, sexual conduct in the workplace. A mandatory verdict for the defense. Sexual conduct in the workplace. Not, in fact, specifically, the judge told the jury, you may consider conduct with people who are not Mr. Rogers, other workers at Cognex, even behavior off-site.
Well, now we're not talking about your quid pro quo claim.
No, Your
We're
Honor.
talking about the hostile work environment.
We are talking
claim.
about that, and also
And whether or not she was a willing and active
That's correct.
participant in the
Yes.
work environment,
Yes.
and therefore it was not hostile or intimidating to her, which is what she has to establish.
And that was the issue. I've talked in my brief at great length about this welcomeness requirement, how it's invited a great number of abuses. And the abuses really sort of originated in that Meritor Bank case versus Vinson by Justice Rehnquist, Chief Justice Rehnquist, where he said that this propensity evidence is admissible to prove welcomeness, that the plaintiff welcomed specific acts of sexual misconduct, or sexual conduct, I should say. And after that, the federal rules people passed Rule 412 in response to Vinson. It took about 4 or 5 years to get Rule 412 passed in response. And Rule 412 said, well, we're not going to allow this sort of evidence, and imposed a balancing test.
But wasn't the judge's an essential requirement of harassment is that the plaintiff was bothered by the conduct. So her state of mind is important because she may or may not be bothered, and if she isn't bothered, it's not harassment. So
Yes, Your Honor.
So why isn't the judge's instruction correct?
The judge told the jury, the instruction allowed the jury to find that even if she was bothered by Rogers' misconduct, there must be a defense verdict if she herself engaged in sexual conduct in the workplace.
With others.
Any sexual conduct in the workplace.
That's a pretty broad reading, I think, of the
Well, if you'd like, Your Honor, let's take a look at the language of the charge.
And again, this is a charge with respect to hostile work environment. This isn't a charge with respect
Sexual
to
harassment.
This isn't a charge with respect to someone claiming that the failure to provide sexual activity was a basis for some specific.
This charge concerned the subjective element of a sexual harassment claim, namely that the plaintiff must find the conduct unwelcome or offensive. Mm-hmm. And over objection, and by the way, you'll see in the charge conference, plaintiff's counsel specifically objected to this proposed language submitted by Rogers' counsel. And to my shame, I find that this specific page of the proposed instruction that was objected to was omitted from the appendix. It's been fixed today. So this court will get page 341A, which was the proposed charge, I beg your pardon, and to which plaintiff's counsel objected at the charge conference and also at the end of the charge itself. The judge said, Dahms must prove that she actually found the conduct to be hostile, intimidating, or threatening, and so on. In making this determination, you must consider the totality of the circumstances, et cetera, which conclude any evidence of Ms. Dahms' sexual conduct toward Mr. Rogers, of course, that's fair, as well as any evidence, if there was any, of sexual banter or comments she engaged in with other co-workers. For example, you may consider evidence of how she dressed, the type of language she used, and evidence of sexual behaviors toward co-workers other than Mr. Rogers, both inside and outside of Cognex. So the broad base of propensity language about my client having nothing to do with Rogers when he wasn't even there, and then the judge told the jury, in the alternative, and I'm going to leave out the ors,
But it's her state of mind, so it doesn't matter if Rogers is there. It's how she feels about the environment.
Well, Your Honor.
So why does he have to be present?
If I may, Your Honor, what this propensity language does, and it's exactly what the defense wanted it to, was to convince the jury that my client was the sort of person who would have welcomed this specific sexual conduct. This is not allowed in rape cases, and this should not be allowed in sexual harassment cases. That she was such a low person, such a degraded person, such a loose woman that no matter what he did, she would not have had a problem with it. That's what propensity evidence does. It sets up the slut defense.
Well, I thought you were, maybe it's the same, I thought you were making a slightly different point, which is that it suggested that if there were sexual conduct to which she didn't object by somebody.
By others. Yes.
That precluded her from claiming that whatever might be true in a general sense, I am specifically bothered by Mr. Rogers.
That's exactly what the charge told the jury, Your Honor. If you find that Ms. Dahms was a willing participant in sexual behavior in her workplace, not with Rogers, in her workplace, then she has not proven this subjective element of her hostile environment sexual harassment claim. That's a mandatory presumption of that what he did was welcome based on her, the way she dressed, the way she talked to other people. In other words, that she was a person of low character, so of course would have welcomed what Rogers did.
Well, help me
the MCAD, by the way, has said this is not the law.
Did she, in her testimony or through others, claim that it was something other than his sexual advances to her which made the environment hostile? Was she concerned about comments made of a sexual nature during the course of the employee, or was the entirety of her claim focused on his sexual advances to her?
The charge focuses on Rogers.
No, I'm not asking about the
Yes.
charge. I'm asking about
Yes.
what the evidence was with regard to what your hostile environment allegation was.
This was the evidence about Rogers, that he made a series of unwelcome requests, unwelcome statements of a sexual nature. When she cut off all conduct with him, he then started to punish her with negative statements in the workplace. And there was an element of the claim that had to do with, as I understand it, as I recall it, one time in 1998 when the CEO met with her and said, "We think you made this up about Rogers. I don't believe you," and made comments about her real problem was that her eggs were getting rotten and that she dressed too sexy and that she seduced him and she encouraged him. So those statements by Mr. Shillman were also an aspect of this claim. It was not particularly focused on, but they did keep that alive. But this charge didn't say sexual conduct with Mr. Shillman, which also would have been appropriate, I suppose, if we had been focusing on that particular act of sexual harassment that was alleged. That's my answer to your question, Your Honor.
And I guess my question then is, how could the jury find, if that's your hostile environment claim, that sounds very similar to your quid pro quo claim in, at some level, your retaliation claim, which you also lost on.
Well, the quid pro quo claim, meaning that after she cut off conduct with Rogers and after the sexual stuff, he continued to, it was a continuing violation sort of allegation, I would say, that he continued, then he started punishing her by making cracks about her workplace and her workplace performance. Well, these cases tend to blur the distinction, and this court has actually held that there's a certain overlap in the natures of these claims. So I'm not.
Well, I guess my concern is you're asking us to focus in a lengthy charge on one half of one sentence.
On the subjective element.
As if that is the crux of what the jury's focus was, and it seems that the jury's primary focus is on whether or not this relationship with him, which involved a trip to skiing trips, and it involved going with him with each of their either spouses or significant others to a rafting trip in the Grand Canyon. I mean,
yes,
there was a lot there that appeared to be consensual, and it seems that's what the jury had to struggle with.
Consensual is the equivalent of welcome. And that is the defense that this was all about. Yes, whether or not it was welcome. And the judge said, you've got to decide subjectively whether this conduct was welcome, and on that subject, if you find she was a willing participant in sexual behavior in the workplace, then she has not proven this element of her sexual harassment claim.
But what evidence was there of sexual behavior in the workplace other than her interaction with Mr. Rogers?
Oh, lots. Now, I'm not going to tell you things that didn't have anything to do with he was not around. Nobody said he was around. How she dressed. Once she showed up for a meeting wearing a tight shirt and no bra. She made a crack to a coworker. Nobody else was around. The human resources person overheard her say she was in a bad mood because she didn't get any last night. Oh, let's see what else. How she
so
dressed.
It was this kind of behavior that
that she
being
was,
referred to?
that she, was a sex pot. By the way, it was all contested. Every bit of that evidence was contested.
On both sides. All of it. That's
Yes,
why it was
yes.
ultimately a jury question on so many of these
whether she
credibility
was a
issues.
sex pot was not relevant unless she was a sex pot with Mr. Rogers. The MCAD has squarely said that, and they've said it over and over again. They've said it in no uncertain terms in their brief. So sex pots get to win sex discrimination claims, even if the jury bought all of that evidence about her. They get to win. Sex pots get to accuse other people of rape. This kind of stuff, this kind of smearing of a person's character in order to cloud the jury's ability to assess her credibility on the specific acts that are being alleged is something this court needs to address. It's addressed it in the rape context, and I'm asking that it address it in this context as well.
I want to ask you about the where you begin in your brief, which is about the settlement.
Yes,
issue.
Your Honor, thank you.
I understand the public policy argument, and I actually think, there's value to your point, your secondary point, which is if this comes in, your client should have been able to explore the settlement letters and stuff like that. But I guess my question is, your first point is this shouldn't have come in at all. It was inadmissible.
Yes.
Public policy says it shouldn't come in.
Yes.
What does somebody like Dr. Shillman do who needs to defend against a retaliation claim, needs to advance a reason that is not retaliatory, and let's just assume, forget bad faith, whatever, let's just assume that this absolutely was his reason. How does he get at it? Or is
he only
what
gets
does
to
he
put
do?
in admissible evidence of a good faith reason. So it's hard to exclude that, Your Honor. The judge has to make a credibility call about whether this is probative of a good faith reason. Dr. Shillman was represented by counsel. That's on the record at this time. And
Okay,
as the
but I
MCAD
guess what I'm asking
Yes.
is, let's assume the judge makes that credibility call, that it
Yes.
was. I mean, I'm not saying you have to say it in this case, but theoretically, it absolutely was a good faith basis for Dr. Shillman's thing.
Then we weren't allowed to show it was a pretext.
Oh, okay, but that's my point. That gets to the second point.
It
But
does.
your first argument is nobody ever should be able to put this in. And I guess I don't know how that would work.
Well, if someone says, I read a settlement proposal, and the settlement proposal said, I would like to be let out of my non-compete agreement, and I'm the CEO of a company, and I read that settlement proposal, and I say, wow, that's a threat. She's going to leave the company and compete with me. Is that person allowed to make that statement when that person is represented by very competent counsel? Should that be permitted?
Well, let's assume.
I think no.
Well, let's assume that it was. Could you, I'm not clear on your argument. Exactly what did you want to have admitted to show that this was a pretext?
Well, I mean, once we objected
Once the
to
judge,
its
right, you
admission.
objected, I understand that, and the
yes,
company got it in.
that's
But
actually-
then what did you want to do?
There's a document that we tried to admit.
Okay.
It is reproduced at page 369 of the appendix, which is
You
a
wanted to get in
partially,
another letter, is
yeah,
that
it's a
it?
partially
Okay, that's what I wanted
redacted
to
version
know.
of the settlement letter itself, with big letters at the top for settlement purposes only, and it lists
Okay, how would that have
counter-proposed.
helped? How would that have helped you with a jury? Because I understand the legal argument.
Sure.
that settlement shouldn't come in. A jury.
Because they
could have said to the
it
jury-
doesn't show that it was pretext.
Yeah, hello, This is a settlement proposal. Juries aren't stupid. They know what proposals are. A proposal is not a threat. It's a request.
Well,
And
says in it-
it says, we propose the following settlement agreement, which we would agree to, that she won't abide by her non-compete agreement. Well, it may not have flown with the jury, Your Honor, but it certainly would have gone a long way to saying, this was not a threat, this is a settlement proposal. Just like any other proposal. You're sitting down with your friend and say, well, I'd like to buy that dog.
Gee, I think on the contrary, I think it hurts you, because to me, it gets into the jury's mind even more that here, she's putting in writing that she gets the idea into Stillman's head that she may not abide by her non-compete.
Well, you may be right, Your Honor, but nonetheless, the settlement proposal came in masked as a threat, and the jury was allowed to believe it, and it was a perfect defense to retaliation. That wasn't fair.
Okay, can I just ask you one other quick
Yes,
question?
Your
Honor? On your last point, the movie release date.
Yes, yes.
You did, or your colleague did rest without reserving the right to put that on. I mean, that may have been a slip of the tongue because he reserved the right to put on some other exhibits, but he didn't reserve the right to bring this up. Is that right?
Your Honor will have to read the record and find out if technically that's exactly what happened. There's an awful lot of technical defenses in this appeal where issues were in fact raised. He said, I'd like to put that on later, Your Honor.
Yes,
the judge said, well, we'll deal with this down the line. And after he rested, the judge kept inviting him to put in evidence. But then when he came up with it, he wouldn't let it in. Therefore, flat-out perjury about my client was allowed to be heard as if my client had told Rogers a very nasty sexual story about herself.
Thank you, Ms. Citizen.
Thank you so much, Your Honors.
Ms. Lukey.
Good morning. May it please the Court, Joan Lukey, and with me Elizabeth V. Harry for Cognex and Dr. Shillman. Justine Brousseau is counsel for John Rogers. We each have 10 minutes, so I will try not to talk too fast. Let me begin by making it clear that this case included a hostile work environment, not derivatively as to John Rogers, but separately against Dr. Shillman and Cognex, not for one isolated incident as just referenced by plaintiff's counsel, who was not counsel below, but rather contending that the entire work environment, where the motto was work hard, play hard, was permeated by sexual and lascivious behavior. You can find the specific allegations in paragraphs 21 and 72 of the amended complaint. It is a separate, non-derivative claim of hostile work environment. I would like to say in defense of the trial judge here that Judge Stephen Neal ran a very tight ship in this trial. He did not allow Ms. Brousseau and me to run roughshod over him. He carefully balanced and considered each of these issues, and completely left out of what you just heard were the limiting instructions and exclusions, which caused, at the end of the day, this case to be as balanced as anyone could hope to find, and a cursory review of the transcripts would review that. Turning to the issue of the charge, 2 paragraphs were taken out of context of a 4.5-page charge on hostile work environment. Immediately before and immediately after those 2 paragraphs, Judge Neal made it clear to the jury that they were going to be looking at allegations against Cognex and Shillman on the one hand, and allegations against John Rogers on the other with regard to hostile work environment. The hostile work environment claims as to Shillman and therefore Cognex, Shillman being the CEO, had nothing to do with John Rogers or any advances allegedly made by him. They had to do with allegations both about comments allegedly made by Dr. Shillman over time, especially at various parties, and they had to do with the party atmosphere itself. Confronted with those claims, of course, the judge had let in limited, carefully tailored evidence that would bear on the 5 Ramsdell factors for hostile work environment. The judge charged on, in volume 6, 19-166 through 171, on those factors. The Ramsdell charge was perfectly delivered. In the 2 paragraphs that are referenced, what was occurring was that in the first two phrases, there were three phrases that were being used. In the first two, he was addressing first Shillman, then Rogers. It was not a situation where he directed the jury, if you read the context, to return a defendant's verdict, even as to Rogers, if they found that her allegation or that the willfulness of her participation in other areas had occurred. Rather, what he said to them was, if you find that Ms. Dahms was a willing participant in sexual behavior in her workplace, that, he had already described earlier, was the reference to the Shillman Cognex charge of hostile work environment. Or, next phrase, that she willingly participated with Mr. Rogers in sexual banter or discussions of a sexual nature. That, he had already explained, was the Rogers charge. Or that she did not consider his conduct to her at the same time was occurring, I'm sorry, I missed a phrase. At the same time it was occurring that she has not proven the subjective element of her hostile environment sexual harassment claim. That charge is correct if you understand that both before and after he has said we've got two different hostile work environment claims you're going to have to decide. Immediately after this, he goes to the questions and says, first, let's go to the special verdict question on John Rogers. Then I'm going to jump you ahead to point out that there's a separate hostile work environment verdict charge, or question rather, for Shillman, which would then relate to Cognex as well. Now, if you understand that that is the context, even that two-paragraph piece of the charge is absolutely accurate. The first two, one against Shillman, one against Rogers, deal with the welcomeness factor, the willing participant factor from the Ramsdell case. The third one deals with the subjective factor, factor number 4 or 5 from the Ramsdell case, and he had just listed those for the jury. So what the plaintiff has done is to go in, pick out two paragraphs without giving you the preceding paragraphs in which Judge Neal very carefully laid out and very accurately laid out the Ramsdell charge, and left out the fact that immediately after those two paragraphs he went to the special verdict forms to point out that they were separate because the allegations were separate against Rogers and Shillman. And in that fashion, they have accused this judge of giving a charge that compelled the jury to return a defendant's verdict, including with regard to Rogers, if they found any willing participation in the workforce. That's not what happened, and that's not fair to Judge Neal.
Let me ask you this. With respect, is it your position that if you have a non-derivative hostile workplace environment claim, that propensity evidence comes in?
Yes, absolutely. It's Ramsdell. The judge charged under Ramsdell. He conducted the trial under Ramsdell. And what's really happening here, rather subtly via the plaintiff and much more directly via Neela's amicus brief, is that they want a reversal of Ramsdell. Ramsdell is governing law, was governing law back in 2003 when this was tried 6 years ago. It was governing law back in 1998 when the events at issue occurred, and Judge Neal meticulously followed Ramsdell. I mean, if you go to the charge that immediately precedes those paragraphs, you're going to find that he lays out Ramsdell quoting exactly right, the 5 factors, and in that instance, unless you're going to retroactively reverse Ramsdell, propensity evidence comes in if a plaintiff chooses to proceed with a pervasive hostile work environment charge, saying that the entire environment is sexually charged.
But this is not evidence with respect to, this is not propensity evidence outside of the workplace or interactions with coworkers.
Well, actually, the evidence here was all inside the workplace, but if you look at the Ramsdell language, technically it could have been outside the workplace.
Even
too.
with
No. There have to have been employees present. I mean, you could be in a bar situation or some such. In fact, a lot of the plaintiff's evidence related to the social events that occurred off premises. And by the way, the evidence was brought in by her counsel. It was not Ms. Sibison at the time, but it was her counsel who put Dr. Shillman on first and asked all of these questions, and then put Ms. Dahms on and asked all of these questions, there was no doubt that they were pursuing a claim that there was a sexually pervasive environment at Cognex. And therefore, the defense was absolutely entitled, because factor number 3 in the Ramsdell 5 factors is the welcomeness factor or willing participant factor, to show, as they did, that the plaintiff was a very active participant in the activities about which she was now being heard to complain. Almost every point in this case was seriously contested. It was Ms. Dahms on the one hand, and Dr. Shillman, Mr. Rogers, and various other employees of Cognex on the other. The jury entirely rejected Ms. Dahms' contentions. And you should know and be focused upon the fact that these included evidence that the voicemails from Mr. Rogers that she had taped were in response to voicemails of the same kind that she left him, precipitating his response, and then deleted. So the jury, that's what the jury's there for. They believed it, and they proceeded with it. Let me turn very quickly, if I may, to the settlement letters issue, since that was the lead issue for this in this brief. No settlement letter actually went into evidence. As the plaintiff's brief correctly notes, it was that there were 2 paraphrasings that went in. And the context is that plaintiff's counsel questioned Dr. Shillman, putting him on the stand, about the restrictions that were imposed, and Dr. Shillman said, I imposed those restrictions because of the statement by counsel that she was leaving and would not be bound by her non-compete. Now, this is the question that I asked without objection, if I can quickly get to it. Can you tell us, sir, each and every reason why you were placing certain restrictions on Ms. Dahms? No objection was made. Answer, there was only one reason. She told us through her attorney that she intended to leave the company and that she intended to compete with the company. After the answer, there was an objection which the judge overruled. There was no motion to strike. I see that my time is up. The only document that came in was Exhibit 41. It was an operative document that set forth the terms of the restrictions. It contained a one-line reference to one of the attorney's letters, and the judge did a very careful weighing that you will see that it was duplicative of other evidence already admitted.
Can I ask one question?
Sure, you can have one, I'll have one.
Oh, well, then you go first. I just have a question about the statute of limitation defense.
That's only for Mr. Rogers.
Then I'll address it to Mr. Rogers.
Defer if you don't mind.
Okay, fine.
What has happened with respect to your answer to me about a hostile work environment claim and propensity evidence? How has, in the federal courts, how has Federal Rule Evidence 412B impacted that?
It hasn't changed the rule, Your Honor. We submitted a motion to file a reply brief to the MCAD in which we laid it out for you. I don't know yet whether a decision has been made whether to allow that reply, but the reason for the reply was that the MCAD went further than the plaintiff in contending that the rape shield law was applicable to sexual harassment. It is not in Massachusetts, and it is not federally. Since Rule 412 was enacted, the case law has not changed. The evidence still comes in for specific purposes where there's a hostile work environment claim. And frankly, given the nature of the allegations here, which was conduct that was verbal in nature, to suggest that it is the equivalent of rape is bothersome, to put it mildly.
Thank you, Ms. Lukey. Ms. Pousseau?
May it please the Court, my name is Justine Brousseau, and I argue this morning on behalf of the individual defendant, John Rogers. The issues that have been appealed by the plaintiff here that affect Mr. Rogers are what I would classify as the behavior issue, the instruction issue, the Donovan preclusion testimony, as well as the movie issue. And I think the best place to start my argument this morning is with the evidence on the behavior which Ms. Lukey has just talked to you about. The statement of facts that has been submitted to this court by the plaintiff simply does not present a fair and adequate representation of the evidence that was introduced at this trial on Ms. Dahms' various claims. In this case, very unusually, Ms. Dahms chose to put on as her first witness, and he testified over a period of almost 5 days, was the defendant, Dr. Shillman. And it was through Dr. Shillman that the plaintiff herself began to introduce and open the door to introducing this, what they are now trying to characterize as propensity evidence. And they have represented this to this court that it was the defendants who bombarded this jury with evidence of Ms. Dahms' loose, immoral character. And one who looks at the transcripts and the arguments in this court, that simply is not the case. As I set forth in my brief at page 10 and 11, what the plaintiff omits to represent to this court, that in fact it was her in questioning Dr. Shillman on direct examination who asked pointed questions about Ms. Dahms' promiscuity and sexually seductive dress, to which Dr. Shillman responded to those questions. It was then again on direct examination when they put Ms. Dahms on the stand that her counsel asked her the question, and it is in volume 6 at 239. It's in volume 2 of the materials that was submitted to the court. The question that her counsel asked her was, let's talk about your attire, your work attire at Cognex. Would you describe it as provocative, seductive in any way? To which Ms. Dahms responded, absolutely not, no different than what I am wearing today. And then he further asked her, can you describe in general what you would wear, the type of clothing, the maker, the labels? And she answered, I typically would wear business clothes, business suits. I would buy Jones of New York or those types of brands, but you know, I would consider them to be fairly conservative, standardly professional. This was not testimony that the defendants elicited from Ms. Dahms. But what it actually went to, rather than how they are trying to characterize it, what it went to for the defendants was Ms. Dahms' credibility. And this trial, Your Honors, was all about the credibility of these parties. Ms. Dahms brought very serious allegations of sexual harassment against my client, Mr. Rogers, in both the form of hostile environment as well as quid pro quo, as well as a retaliation claim. When this trial opened, the plaintiff was still attempting to proceed against my client on an assault and battery claim as well as an intentional infliction claim. After the opening and then on directed verdict, those three claims were eliminated and were not put to the jury. But in this case, the claims that went to the jury against my client were quid pro quo, hostile environment, as well as a retaliation claim. Also presented to the jury and at the beginning of this trial were claims of hostile environment sexual harassment as well as quid pro quo harassment against Dr. Shillman. And Ms. Dahms also claimed that the entire work environment retroactively, in her opinion, after she filed her charge, was a hostile environment, that she tried to persuade the jury interfered with her ability for full participation in the work environment. So her own testimony regarding her clothing, the defendants then, I believe, as was their right and obligation to their client, put on two witnesses in their case in chief. That was Marilyn Matz and Joanne Woodward. And we simply asked those very simple questions that had already been elicited and introduced to the jury to challenge, as was our right, Ms. Dahms' credibility that her work attire was business suits as she was presenting herself to this jury at trial. Those two women testified very limited instructions by the judge to time period and scope as to their observations.
What did they say?
Marilyn Matz testified first, and Marilyn Matz testified that her observations of Ms. Dahms' attire was not the type of professional conservative attire she was presenting at trial, and she testified specifically that once Ms. Dahms filed her charge of discrimination in August of 1998, she observed a significant change in Ms. Dahms' attire in the workplace, and she described how she went from short skirts and low tops to, I believe she described it as her hemlines gained 18 inches. I set this testimony forth in my brief at page 11, and it's Marilyn Matt's testimony on October 28th. We also solicited very limited testimony from Joanne Woodward, who was the Vice President of Human Resources, as to her observations regarding Ms. Dahms' clothing and attire at work. And she also testified as to the fact that she did not present herself at work prior to filing her charge of discrimination in the manner she was presenting herself at trial. We look at this as not a trying to, as I believe the Neela said, present the slut defense. What we were trying to present was a credibility issue, which there were many credibility issues that we showed through Ms. Dahms' testimony, that in fact she was not sexually harassed by Mr. Rogers, she was not sexually harassed by Dr. Shulman, and that she did not find the Cognex environment to be a hostile environment.
Could I ask you a question about the voicemails? Did those come into evidence?
Yes, the voicemails came into evidence, and I believe they are attached in the appendix. What we did is we agreed with plaintiff's counsel to come up with transcripts, and we spent a considerable amount of time getting the transcripts into a form that both sides could be comfortable with. Because what had happened is Ms. Dahms had
I understand she kept the reply message and not necessarily hers.
Right, but she taped them onto another device, and some of the content of the voicemails were inaudible. So we spent some time trying to agree what those were. We marked the transcripts, but what happened at trial were some of the actual messages were played for the jury, and questions were posed to my client at trial regarding whether it was his voice, whether he had left those messages. What also the jury heard was the fact that Mr. Rogers testified, and is apparent from those transcripts that you can see in the appendix, is that in many instances it is clear that he is responding to a voicemail of hers. Got your message, sorry I missed you, tag you're it. Responding to a question that she had posed. Unfortunately, my client didn't recognize the fact that he should have been tape recording her messages to him as well, and so we did not have the benefit of those, but there was certainly testimony at trial that she was leaving in-kind messages for him, and I think the transcripts reflect the fact that in many instances he was responding to her.
Before your time is up,
Go
I
ahead.
just wanted to ask you about the statute of limitations defense, whether you waived it by not raising it on appeal or in a cross appeal.
I did waive it, and the sole reason that I raised it in my brief was for this reason, is my understanding is that the standard that you will be applying here is abuse of discretion, and that you would have to find that Judge Neal abused his discretion and should not have made the evidentiary rulings that he made. And what you would also have to show in order to reverse that would be that this was prejudicial error. And so the sole purpose for incorporating two arguments into my brief on the issue of statute of limitations, as well as the fourth prong of the sexual harassment standard, was to say that even if you found that there was an error on that, there was serious, serious concerns here regarding whether Ms. Dahms' claims was even timely and whether or not she would have, based on her own testimony regarding raises and promotions and things that she got at the time and throughout until after my client was left the company in November of '98, her claim was flourishing, and I questioned her at trial at any of these actions that she claimed Mr. Rogers took against her. Did it affect her salary? Did it affect her title? Did it affect her job, her budget? And she consistently responded that no, there was no tangible effect to her or her participation in the work environment as a result of that. So I really raised it more to go to the prejudicial error.
Thank you, Ms. Boussard. We'll take a short break.
Your
I'm sorry.